Imagine if the most popular rifle in America, the AR-15, and standard capacity magazines were declared outside the protections of the Second Amendment. That's not just a hypothetical. That question is currently sitting in front of the Supreme Court for consideration right now. The question before the court is very simple. Does the Second Amendment guarantee the right to possess AR-15s and magazines? Let's talk about some critical new developments in these cases and what's potentially happening going forward. Before we dive in, if you want to support the channel, one of the best ways is simply to subscribe and click that notification bell. Turn on all notifications because that helps ensure you actually get these videos when I release them. I also want to thank one of the main supporters of this channel, Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, Attorneys for Freedom, and they're always expanding their memberships and benefits to make sure you get the most out of your coverage. In fact, one of the new things they added is guaranteeing 4 attorneys to your self-defense case. If you want to check them out, use the links below, and if you use my code ARMSCHOLAR, you can get $25 off your sign-up plan. As I mentioned in the intro, we're discussing critical rifle and magazine ban challenges that are currently going to the Supreme Court once again for conference. They're being considered by the Supreme Court this Friday, and the implications are massive. The primary case I want to talk about is Vimont versus Cook County. In that case, the petitioners are individual citizens along with organizations like the Second Amendment Foundation challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons as defined by that ordinance. That ordinance essentially includes over 100 rifles by name and then also bans a bunch of rifles by characteristics with features like pistol grips, folding stocks, muzzle brakes. It's very similar to what a lot of other counties, cities, and states like California have done. These cases are trying to leverage recent statements made by some of the justices, like Justice Kavanaugh after the Snope denial case, where there was a rifle ban out of Maryland. That Snope case went to the Supreme Court and was denied, but Justice Kavanaugh said they would need to address the rifle ban issue in a term or two. The plaintiffs are now pushing this case and the Duncan case as vehicles to fulfill those promises. The Supreme Court has once again relisted review of these cases for another conference at the end of this week, on January 16th. This could mean several things and gives us insight into what might happen going forward. Let me give you the background on how this case got in front of the Supreme Court. Back in 2021, the rifle ban lawsuit was filed in federal district court in Chicago. The petitioners challenged the county's ban under the Second Amendment. Flash forward to 2024, while the case was pending, Illinois passed a statewide assault weapon ban, overlapping with some of the Cook County restrictions. Around the same time, the Seventh Circuit decided a case called Bevis versus Naperville, upholding Illinois' law in claiming that AR-15s were too militaristic to be protected arms. They ruled that firearms useful in military service could be restricted by a state or locality. Think about how insane that reasoning is. The Second Amendment was specifically designed to protect weapons useful for militia service, yet the Seventh Circuit says those are the exact weapons that can be banned. The district court, bound by the Seventh Circuit's ruling, upheld Cook County's rifle ordinance. The district court issued summary judgment in favor of Cook County. Then, going into 2025, right after the Snope case was denied review and you had that statement from Justice Kavanaugh, the Seventh Circuit quickly affirmed what the lower court said, upholding once again Cook County's ordinance. The Seventh Circuit leaned heavily on what happened in Bevis, treating AR-15s as essentially civilian versions of M16s, too militaristic and therefore outside the Second Amendment's protections. This reasoning completely contradicts both Heller and the original understanding of the Second Amendment. Now the petitioners are asking the United States Supreme Court to step in and resolve this conflict. They're asking the Supreme Court to declare once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states and localities are banning. The petition argues that circuit courts are split and deeply confused on how to apply Heller and Bruen when it comes to rifles and these types of restrictions. Some courts say that AR-15s are arms but can still be restricted anyway. On the other side, you have some circuit courts essentially saying that rifles like these are not arms at all, and therefore have no protections. Cook County responded by arguing that the court should once again simply deny review of this rifle ban case and punt this issue. Cook County argues this case doesn't warrant the court's attention for multiple reasons. First, they say there's no circuit split on this issue of rifles being protected arms. Second, they claim this case is a poor vehicle since the plaintiffs allegedly failed to follow basic court procedures, skipped discovery, offered no admissible evidence, and rushed the process to get to the Supreme Court. Finally, Cook County contends the lower courts were right on the merits, even if all that other stuff is overlooked. In summary, they say this case is procedurally defective, legally settled, and not the right vehicle for the Supreme Court to revisit the assault weapon ban issue. At its core, this case asks the Supreme Court to finally do what we've been asking them to do for many years, take up a state or locality rifle ban and hopefully strike them down. This case went to conference recently, last Friday, along with another Second Amendment case, Duncan versus Bonta, which deals with California's magazine bans. These two cases have gone to multiple conferences now together. They've survived multiple conferences, even though some other Second Amendment cases went to those same conferences but were then denied on the following order list. But these two are still surviving and have been relisted once again for conference this Friday, January 16th. You may wonder why the Supreme Court is relisting these cases so many times and why this is important for the potential outcome. All the Supreme Court analytics and tracking data on prior cases show that a case has higher odds of being granted review by the Supreme Court if it's relisted, but only one time. According to data from the court's 2016 to 2020 terms, between 31 and 43% of petitions that were relisted at least once were eventually granted review, and between 66 and 75% of all cases that were granted review were relisted at least one time. So the fundamental truth is that a case relisted just once has a far better chance to be granted review by the Supreme Court. But the other side of that, the data also shows that multiple relists, like what's currently happening with these cases, could potentially be worse for these cases and could be a bad sign similar to what we saw happen with the Snope rifle ban case. Duncan has been relisted, I believe, 5 times now, and Vimont has been relisted 4 times. The more that happens, potentially the worse that could be for these cases. The Snope case was relisted, I believe, 10, 11, 12 times and was eventually denied by the Supreme Court. Then you just had a dissent from Justice Thomas and a statement from Kavanaugh. What that means is that all the data shows a case becomes less likely to be granted review the more times it's relisted. The chances drop more and more as it's relisted additional times. Now, that's not to say there are no cases where there have been 10, 11, 12, even 14 relists, and the Supreme Court still granted review. In fact, Bruen had a high number of relists. The Cargill bump stock case had a high amount of relists and was still granted review by the Supreme Court. So the chances aren't zero, but it is concerning that we need to keep our eye on. As they continue to get relisted more and more, it could be an indication that the Supreme Court is simply going to deny these cases, punt them once again, and maybe you just have a dissent. To this point, the Supreme Court has avoided the whole rifle and magazine ban issue like the plague. However, we will know very soon whether Kavanaugh's promise that they would take up this rifle ban issue in a term or two was actually a true statement or just another empty promise made by the Supreme Court to keep everybody happy. We'll find out once again after this conference this Friday, January 16th, when the rifle ban and magazine ban cases go to conference. We're going to keep our eyes on the order list the following week to see ultimately what the Supreme Court decides to do. Here's what's at stake. If the Supreme Court denies these cases, rifle bans and magazine bans will continue spreading across the country. States like California, New York, Illinois, Connecticut, Massachusetts, New Jersey, Maryland, and Hawaii will keep their bans in place. Other states will feel emboldened to pass similar restrictions. The most popular rifle in America, owned by millions of law-abiding citizens for lawful purposes like self-defense, hunting, and sport shooting, would effectively be declared outside Second Amendment protection in multiple states. Standard capacity magazines that come with most modern firearms would be banned, forcing gun owners to use artificially limited magazines that put them at a disadvantage. On the other hand, if the Supreme Court grants cert in one or both of these cases, we could finally get the clarity we've been waiting for. The court would have to decide whether AR-15s and similar rifles are protected arms under the Second Amendment. They'd have to address whether magazines are protected, and they'd have to provide guidance to lower courts that have been twisting Heller and Bruen beyond recognition. A Supreme Court ruling striking down these bans would affect millions of Americans in restrictive states. It would reaffirm that the Second Amendment protects modern firearms, not just muskets. And it would send a clear message that states cannot simply ban entire categories of commonly owned firearms based on cosmetic features or political preferences. The next few days are critical. This Friday's conference will determine whether these cases move forward or get kicked down the road again. The following Monday, we'll get the orders list showing what the court decided. I'll be watching closely and will bring you updates the moment anything happens. Make sure you're subscribed with notifications turned on so you don't miss the breaking news when it drops. Drop a comment below with your thoughts. Do you think the Supreme Court will finally take up these cases, or will they punt again? Share this video with every gun owner you know, because this affects all of us. As always, thank you for your support. Never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.